Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Friends, very recently I have made a video wherein the Honorable Supreme Court of India clearly stated that raising the marriable age of a woman from 18 to 21 years is in the domain of the legislature. That means the government of India, they have to make an act, not the Supreme Court. Likewise, another issue has come before the Honorable Supreme Court of India, right? In the case of Shailendra Mani Tripathi versus Union of India and others, in civil, petition civil number 172 by 2023, dated 24 to 2023, yesterday, right? Honorable Justice, Chief Justice of India, Dr. D.Y. Chandrachud and P. Pamidghantam Srinasimha and J.B. Parthiwala, they refused to entertain a public interest litigation, right, seeking menstrual leave compulsory, so to the female students and working women, right? So they clearly, Honorable Supreme Court of India clearly stated that it is in the domain of policy making. That means the government has to make an act, right? So anyway, some discussion before the refusal of the bill, some discussions went on, right? Please remember, for example, if menstrual leave is made compulsory to women, it is argued that, please remember, it is argued that the companies may be inclined not to give employment to the woman, so it will discourage the woman being appointed. Of course, I may not be agree, but it is one of the defense points, please remember. And ultimately, Honorable Supreme Court of India, even though the petitioner said that it is a violation of equality before law, Article 14 of the Constitution of India, and please remember, it is actually the woman who have to agree. The women suffer physiological as well as health issues also during the menstrual cycle. This is quite natural. Of course, the pain they suffer during particularly that menstrual cycle, normally it will be aching them. Better to give them leave, but if every month 3 days leave is given, then it may be difficult for the employer also, right? Ultimately, Honorable Supreme Court of India directed the petitioner to file the same or to approach the Union Minister, Ministry of Women and Child Development, I think central government, so they can pass some law so that it can be implemented. Here, I have to make you remember that Dr. Shashi Tharoor in 2018, Dr. Shashi Tharoor introduced a woman's Sexual, Reproductive and Menstrual Rights Bill. Sexual, Reproductive and Menstrual Rights Bill, where it was suggested that the sanitary pads should be made available freely. Of course, it was actually a movement taken by so many NGOs also. Even Shailaja, I remember her name, full name I am not able to recollect immediately. So she is running a non-governmental organization. She is in USA. And she used to supply the so-called free sanitary napkins to the children in Ipurpalam High School and so many places also. That girl, actually her father worked as a bank manager in Santantalpad area. Even though she is in America, she is doing some philanthropic activities, right? Like that, sanitary pads should be made freely available. But it was the so-called bill has not seen the light till today because of the lack of legislature will to make it a law, to move forward. So this matter is pending. Anyway, this is a topic for discussion. Very good topic, no doubt. It has got pros and cons also. So Let us wait for the positive result. That's all. More than that we can't do. Anyway, it is the legislature that has to take a decision and not the Supreme Court. This is what the Honorable Chief Justice of India said in this particular public interest litigation. Okay, I hope you understood it. Thank you.